Right, sorry about that delay. We're on the record now. This is People versus Everett Bradford, case number 235202. Mr. Bradford. Cheers. Come up to the podium here, please. Record should reflect Mr. Bradford's present here in the courtroom today. If I could have counsel put your appearances on.
Sierra Cole can be at the people.
Thank you, Honor. Jason Thompson, standing in for a record here with the attorney, Mr. Bradford.
Mr. Bradford, do you have any objection to Mr. Thompson acting as your attorney here today?
No, I don't have any objections to him.
Okay. So this is the date and time set for sentencing. Mr. Bradford, did you have an opportunity to speak with your attorneys and go through the pre-sentence report with them?
As best as I could.
Do you need more time to do that today before we go forward?
I really don't know. It's a little bit more prepared, really not.
I'm having trouble hearing you. Can you speak up a little bit?
I'd be a little bit more prepared, but I'm really not. I really don't know at this point. I guess we can proceed.
All right. Well, I mean, you have two options. You can go forward. I can, give you some time this morning to talk to Mr. Thompson and go through the pre-sentence report more with him if you'd like.
If I could.
Okay. Yeah, you can do that. You can have a seat. And the next time we get a break, Mr. Thompson, I'll just do that. Bradford can answer any questions that we have. So, is Ms. Strasburg present?
Yes, I am.
Okay. Mr. Bradford, you can step down. Ms. Strasburg, you come forward.
Yes.
On record in People versus Sarah Crawford, case number 245294. The record should reflect today. If counsel put your appearances on the record.
Sierra Cole can be at the people.
Thank you, Honor. Jason Thompson, covering here with the attorney for Ms. Strasburg.
Strasburg, do you have any objections to Mr. Thompson hearing on your behalf today?
No, sir.
Ms. Strasburg, have you had a chance to go through the pre-sentence report with your attorneys to talk to them about that?
Yes.
Okay. You seem unsure. Do you need more time to do that?
I haven't talked to him at all today because I came in and he had been talking to somebody and came right back in here. But I went over it a little bit with Mr. Grummer, and I think I can understand pretty much everything.
Okay. As with Mr. Bradford, if you want to have a chance to speak with Mr. Thompson before we go forward today, I'd be more than happy to give you that time to do that.
Yes, please. I would just verify a couple things.
Okay. All right. Mr. Gentilla. Ms. Strasburg, if you want to go ahead and
Okay, thank you so
have a seat
much.
for now. Thanks. Are you ready on this Mr. Gentilla's case, Mr. Thompson?
Yes, thank you.
Ms. Coe?
Yes.
All right. People versus Justice Gentilla. Sir, if you want to come up to the podium here, please. So we have two files here today, 245318 and 245331. Last month we had a hearing. We determined that the judge would have to preside over the preliminary exam. That's the newer file. I believe that's been done. We have now the files found over the circuit court. Mr. Thompson, can you tell me the status of these files?
Yes, the second case was bound over yesterday, Your Honor. They're both in front of Your Honor now. We have plea offers in both cases. We quite frankly have an uncharged crime that's taken up a lot of our time right now. I don't believe it's a crime. Prosecutors investigating. I think within 30 days, there's a good chance we have a resolution here.
Okay. Ms. Coe?
That is a correct statement of where we are. I have let them know that there is a uncharged issue. I have to meet with the doctor. The doctor was not available. So we've been working on trying to get that set up to go over the photographs, but that's not part of these two cases. I would ask for 30-day adjournment And after that, if we don't get it resolved, we can move forward.
Okay, if there is no resolution, is either side going to be seeking to join these files for a trial, or are they based on completely separate circumstances on this?
We haven't really discussed that because I think we have them resolved. We're just waiting to see what the other case is.
Yeah, I mean, they're separate incidents in time, Your Honor. So I would be asking for separate trial.
Okay. All right, so the court will set both of these files for a plea hearing at next month's full motion day. Mr. Gentile, do you have any questions? Your Honor. Okay, thank you. That's all for this hearing today then. Recess, Mr. Thompson, once you've had an opportunity to speak with Mr. Bradford and Ms. Crawford, Cernol, and we'll take it first.
Thank you, Your Honor.
Right. Before we go back on the record, I guess I just had a question for each of Mr. Bradford. Did you know that Mr. Germerty was not going to be here today, before today? Oh, he didn't, Mr. Crawford?
He called me last night.
Mr. Germerty did?
Yeah.
Before that, you didn't
No.
have any idea that he wouldn't be here today? All right, so, based on that, sentencing is a critical stage of a criminal proceeding. I think it's extremely important that individuals have the attorney they've been working with present for a sentencing hearing, and if they don't, I think it's extremely important that they're aware of that well in advance of the hearing, so that you would have had a chance to talk to Mr. Thompson prior to the day of the morning of your sentencing hearing. I do want to note for the record that when Mr. Germerty indicated to the court that he wasn't going to be here today back in July, the court instructed him in writing by email to not only get coverage, which he did, Mr. Thompson, but to get prior approval from his clients. So in my view, that's something that he should have done well in advance of today's hearing, so that people were aware of that and would have had a chance to talk to Mr. Thompson, make sure that you felt comfortable with him and his familiarity with your case. So in my view, Mr. Germerty hasn't done what he needed to do to make sure that you all were ready to proceed today. He didn't follow the instructions of the court in doing that. So in a critical hearing such as a plea hearing or a sentencing hearing like we're doing today, in the interest of justice, I don't think I can proceed. So the court's going to reset both of these hearings. You'll be notified of the date and time of those hearings, and Mr. Germerty will continue to be your attorney, and you'll have an opportunity to consult with him. Mr. Thompson, the only thing I can say, I'm going to address this with Mr. Germerty directly, but as the administrator of the contract, I'm going to ask that you address it with him as well, that he needs to follow the instructions of the court. He's not going to be appearing on that. So, you folks are free to go for the day. Thank you. Our next hearing is at 10 o'clock with Vineyard. His attorney has requested and got prior approval to appear by video today.
Your Honor, Mr. LaFernier is here, so as soon as his attorney is available, we could proceed.
You want to make the approach?
Yeah, no.
I don't want to
No, we can go.
two more hearings seems silly.
No.
just wanted to see, we're just waiting for your attorney to connect. Okay?
Yes.
What is happening? Charges. $100. Restitution.
All right, Mr. Zaid, are you able to hear me okay?
I can, Your Honor. Thank you.
All right, we're on the record in People versus Melvin Joseph LaFernier. And sir, if you want to just come up to the podium there. This is file number 245285. If I could have counsel put your appearances on.
Sierra Cole can be up the people.
Good morning, Your Honor. Justin Zaid, attorney on behalf of Mr. LaFernier, who is present in the courtroom. Mr. LaFernier, can you say your full name?
Zaid, is there a reason why you weren't signed in and ready to go at 10 o'clock this morning when the hearing was scheduled?
Your Honor, I was just logging in. It was an issue with the place I'm in right now. That's it. I apologize.
Yeah, so I mean, you've been after my office for at least a week now, trying to appear by Zoom, which I finally granted that request, which wasn't based on some type of work conflict, but a personal reason. I finally granted the request, and then it's 10 o'clock and you're not signed in. Incredibly frustrating from my standpoint, to be here with the client. In the future, to the extent that you are allowed to appear by Zoom, I suggest that you sign on with plenty of time ahead of the hearing date, hearing time, so that to the extent you have any technical difficulties, those can be worked out so you're present and ready to go at the time of the hearing, okay?
Understood, Your Honor. I apologize again. Thank you again for the accommodation.
Just so you know, that's frustration I have with an attorney. It doesn't have anything to do with you or your case, and it's not going to result in a different result for you, okay? Just want you to understand that. I get frustrated when I have attorneys making special requests and then they don't appear on time.
Understood.
But I want you to understand it's not going to reflect that at all.
Thanks, sir.
This is the date and time for set for Mr. LaFernier. Have you had an opportunity to go through the pre-sentence report and talk to your attorney about that?
I have you.
Okay. Mr. Zayed, is there any additions, deletions, or corrections that need to be made to that report?
Your Honor, the only, I guess, clarification that I would have is on the first page where it indicates that under plea agreement, it says must complete sobriety court for plea to misdemeanor. While Mr. LaFernier has full intention and motivation to complete that program, it is, he did plead to the second offense misdemeanor at the time of the plea. So it sounds like somewhat of a technicality, or but that's the only clarification we would have with the substance of the report, Your Honor.
I believe that's correct. I just spoke to an objection clarifying that.
I'm just reading through our notes really quick. Yes, that is correct.
Okay, so Mr. Zayed, I agree that that's a change that needs to be made. So the court will have the plea agreement modified to reflect that.
Okay, and then other than that, Your Honor, I just have to ask for an opportunity to allocate on his behalf.
Yep.
How would you like that worded, Your Honor?
I think if we just take out that must complete.
Okay, just take that right out. Okay.
It'll be a condition of the probation, but it's not a condition of the plea.
Okay, Ms. Wilk will take care of that.
All right, Mr. Zayed, are there any? Oh, I'm sorry, this is a misdemeanor. There are no guidelines. Okay, Ms. Cope, do people have any additions, deletions, or corrections?
Your Honor, part of the plea agreement was the forfeiture of the weapon. I'd ask that that be included.
Okay, Mr. Zayed, any objection to that?
No, Your Honor.
Okay. Ms. Cope, any other corrections?
No.
Anything on behalf of the people for allocution?
Your Honor, I understand the defendant has a good job. His OWIs were very long ago, which is why he got this plea offer. We don't do this very often. We only do it when there's been over a 10-year gap since the second, which is more than that in this case. I really hope that he takes this seriously. I mean, he's getting close to where he's going to end up doing significant jail time if he screws up. So I hope he does this program and he gets it together, because he had a really high BAC here. So I asked the court to follow the recommendation, order the 5 days in jail, which is required by statute, with the 2 days credit, and forfeit the handgun. Thank you.
Thank you. Mr. Zayed, anything on behalf of your client today for allocution?
Thank you, Your Honor. First and foremost, I'd like to thank Ms. Koch and her office for working with us on this matter, and I think we found an equitable resolution to this matter. Your Honor, I want the court to know that Mr. LaFernier is a decorated Army veteran. He has served our country for over 2 decades. He is a 40-year-old man who's unfortunately going through some personal issues in his life, but I bring that up because he has not allowed that, personal adversity to get in his way of his path towards sobriety. Your Honor, this incident happened in April of 23. It's now September of 24, and I stand before you representing to the court that Mr. LaFernier is sober at this point in time, but he understands that the journey towards sobriety is not linear, and it's going to take the rest of his life to overcome such an addiction. And that's why, again, we thank the court for allowing him to get onboarded into the sobriety court program. And really, it has a veterans court element to it, because I think it goes without saying that Mr. LaFernier saw some things during his service, and it still comes back to him till this day. And we want to make sure that alcohol is never a source of or remedy to deal with the issues that he has in his personal life. And so far, so good. But again, it's a long path, and we thank everybody for understanding that. Your Honor, the only things that I would ask the court to consider is the fact that Mr. LaFernier has been on bond for over a year. He has been perfectly compliant, no issues whatsoever. I think that demonstrates that he's a great candidate for community supervision, a good candidate for sobriety court, and I think that is a mitigating factor towards the jail time. I understand that the 5 days in jail are mandatory, but also at your discretion can be held in abeyance. We would ask the court to consider that for a few reasons, one of which the fact that he has been sober and compliant on bond so far, and the fact that this incident happened so long ago, and the other incidents before that happened even farther ago. Your Honor, I think that Mr. LaFernier has demonstrated that he is not going to reoffend. There's a low risk of recidivism at this point in time. And so we'd ask the court to consider holding those 5 days in abeyance and allow him to demonstrate that he is going to successfully complete the sobriety court program.
All right, thank you. Is there anything that you wanted to say today?
Yeah, I just wanted to add, I completely accept the responsibility of my actions. I've learned quite a few things from this. I made a huge error in judgment that I could have lost everything. I'm grateful for what, the opportunity to actually be able to move forward and not lose everything, not lose my career, my family, and everything else. So I'm highly motivated to become the best version of myself, and that's where I'm headed. And I can personally guarantee you'll never see me again here.
All right, I did read through the report. I'm familiar with the facts of this case that brings before the court here today. I also read through information about your own circumstances, background, and history, and so forth. I read a statement that you submitted as well. So I'm pretty well versed in terms of the facts of this case, as well as your background and history and how all of that fits together. There are certainly concerning things about your conduct in this case. The open containers of alcohol, not open, but partial containers of alcohol that you had in your vehicle with you. Obviously, the weapon, certainly a concern with someone who was intoxicated as you were at the time, based on your blood alcohol content, and the fact that you were operating the vehicle. All of those things together create significant danger of injury to innocent people who were on the road, or yourself, or both. It's a fortunate thing that didn't occur in this case, but there was certainly the potential for that, and that's concerning to the court. I do agree that there are a number of mitigating factors here as well. Your military service, the length of time between your last conviction, which is about 17 years, I think. So a significant period of time in which you were not engaging in this kind of conduct. There were some concerning things I saw. I mean, there was an intervening, I think in 2014, disorderly, looked like it was alcohol involved. So I think there's enough smoke here to indicate that there's a problem with alcohol that you have. And just because you didn't necessarily have contact with law enforcement because of it doesn't mean that it hasn't been some kind of a problem for you and that's come through in a few incidents over the course of your life. So I think the fact that this is going to result in you participating in a program like that treatment court is going to be beneficial to you. I think it's going to give you an opportunity to get some tools to deal with something that I think probably has been somewhat of a problem for you
I agree.
over the long term. And I think it's entirely appropriate. I think based on your past history, you're going to be successful. And I think it's going to wind up being a positive thing for you. And just as important to me, a positive thing for our community in that you aren't going to be doing this anymore. You're going to be continuing with a career that provides safety and security to the community as opposed to one that puts people in danger for actions that put people in danger. So the court is going to follow the recommendation. The court is going to sentence you to probation for 2 years. The court is going to adopt as the conditions of that probation all the terms and conditions in the listed in the report, including that you participate in and successfully complete the North Oakland County Veterans Treatment Court. The court is going to order 5 days in the Crawford County Jail with credit for 2 days served. The court will hold 3 days in abeyance to be used at the discretion of the treatment court. Crime victims assessment of $130, or cost of $325, a fine of $200. Testing reimbursement fee of $100, $60, $50 state cost, $30 supervision fee, probation, costs associated with participation. And because this is a misdemeanor, there are no written appellate rights. Even though this is resulting from a plea, you do have the ability to seek an appeal of the sentence if you want to do that. If you did want to file for an appeal, you would need to file your paperwork within the next 21 days. If you have more questions about that, I'm sure Mr. can explain that process to you. Mr. Haven, do you want to meet with Mr. LaFernier here before he leaves today?
Yes, I will. I'll do an orientation with him and get the transfer prepared because he'll be supervised in Oakland County. So.
Okay. Mr. Zaid, anything further we need to address from your side today?
Nothing further, Your Honor. Thank you.
Ms. Coke?
No, thank you.
Good luck to you going forward. That's all for this hearing.
Yes.
Our next hearing is set at 45.
Thank you very much, Your Honor.
Mr. Thompson, are you able to hear me okay?
Yes, thank you.
Okay, we're on the record now in People versus James Paul Brown, case number 214916. The record should reflect that Mr. Brown is present here in the courtroom today. We have Ms. Koch present on behalf of people also in the courtroom, and Mr. Thompson by Zoom on behalf of Mr. Brown. This is set for a hearing today, I think, to modify the conviction in this case, which was operating while intoxicated, third offense, to a second. Is that correct?
It is. He has been successful on his journey here. He is off probation already. So we just have to do this paperwork.
Mr. Thompson, was there anything on behalf of Mr. Brown that you wanted to say today?
No, I think the court has stated it correctly. I submitted the PSI and the certificate of completion that the PSI indicates that if he, successfully completes, this would go from the felony third down to the misdemeanor second. We've submitted the certificate of completion, and we believe it's appropriate for the court to take that action. Thank you.
Ms. Koch, anything further that you wanted to state?
Congratulations to Mr. Brown.
Thank you. Okay, Mr. Brown, I did have a chance to review the file prior to the hearing today. I want to reiterate what Ms. Koch has said in terms of congratulations. That program is not an easy program to get through. It's very demanding. And it requires a lot of effort and really a desire on your part, I think, to successfully complete it. The court can order all kinds of different things, but unless the individual himself wants to participate and get a meaningful result, it just doesn't happen. And so I think that says something about you as a person and your willingness and dedication to live a better life for yourself. The benefit we get as a community is now going forward. You've got some tools to help you, and that you won't reoffend. And so that's the benefit we get. So it's a win-win all the way around. And on behalf of the community, I appreciate the time and effort that you put in to successfully complete this. And it is an accomplishment that you should be proud of, and I hope that it gives you confidence going forward. And of course, it also means you get the benefit of the plea agreement in this case, which is to have that conviction go from felony to misdemeanor second. So the court will enter the appropriate orders to reflect that. Did you have any questions at all?
No, I just wanted to thank you all for allowing me for the opportunity to participate in the sobriety court. It was a tough program, but I really embraced it and saw the opportunity that it could have for me, and it was phenomenal. It's the best thing I've ever done.
Good, and that's the outcome we were all hoping for. Yeah. So, congratulations again, and good luck to you going forward.
Thank you.
Yes.
Thank you.
I don't know if Jason is on Zoom. I know I thought it was going to be here on him. So it's just kind of like waiting.
All right, let's take a short break. We need to have Mr. Thompson here before we proceed. Okay, Mr. Thompson, are you able to hear me okay?
Yes, Your Honor, thank you.
All right, we'll go on the record in two different matters. People versus Arthur Gann, case number 235160, and William Grogoski versus Gann, case number 2311370. The record should reflect that Mr. Gann's present here in the courtroom. In terms of the criminal case, he's represented by Mr. Thompson, who's present by Zoom. We have Ms. Koch here in the courtroom as well. And Mr. Grogoski is also present here in the courtroom today. Both of these files are set for hearing today to monitor payments by Mr. Gann as to the criminal file and the PPO file. I was going to ask Ms. Medler to just provide a recap. Did counsel have any objection to that?
No.
No.
Ms. Medler, if you can maybe address the criminal case first. And then,
So in case 5160, he was assessed 1591.14 in restitution. As of today, he's paid $180 with a balance of $1411.14. In the PPO file 11370, he was assessed a $500 fine. He's paid $180 of that with a balance of $320.
okay.
His last payment was today of $25 on each file.
Ms. Koch, anything on behalf of people today?
It is difficult because I understand the court is in a position, we can't incarcerate people who can't make payments. I think it's important that we keep monitoring this. I mean, the victim deserves to get paid. The victim had to pay this. So whether Mr. Gahn can pay it now or not, the victim got stuck paying this bill when it was due. So I would ask that the court order a specific amount each month for Mr. Gahn to pay, and then we set another hearing for monitoring.
Okay, Mr. Thompson?
I think the court is aware of this, but I would just ask the court to take into consideration, Mr. Gahn's on disability, he has a limited income. He is making payments. I believe they're inappropriate. They are appropriate amounts based on his budget and his circumstances. So in terms of the review, I believe, he is complying with his obligations, and I'd leave it to the court's discretion whether it remains sort of open-ended or whether the court wants to suggest a monthly payment. If the court does, again, I believe the amounts he's been making are appropriate. Thank you.
All right, so as the attorneys are aware, that in order for, I mean, I guess Ms. Koch, to the extent, are you requesting the court to order amounts in excess of what Mr. Gahn has been paying?
Your Honor, I would defer to the court for what's appropriate. I don't know exactly how much he's paying per month. I just know what the balances are, and they haven't gone down very much.
Okay. So Mr. Gahn, the court's gonna require you to continue making the payments that you've been making. The next hearing the court is gonna set for 90 days from now. At that time, Mr. Gahn, I am going to ask you to bring with you
proof of income.
Correct, yeah, so I'm gonna ask you to bring bank statements, pay stubs, or, receipts showing your income from disability or whatever.
It directly goes right into the bank and it shows that it came from the government.
Okay, so I'm gonna ask you to bring 3 months worth of, so this month, the next month, and then the following month, 3 months worth of bank statements. And then Ms. Koch, you'll have an opportunity to review those. Mr. Thompson, I'll ask that you're here in person for that next hearing so that you can look at those as well. And then the court will make a determination as both counsels aware. Mr. Gurgowski, I'll make you aware of this too. Before the court can order specific amounts, I have to make findings with regard to Mr. Gahn's income, and under the law, I can only order certain amounts to be paid based on what his level of income is. So,
Your Honor, can I address the court?
sure.
So, a couple things, Your Honor. First, the defendant was facing several felonies, which got booted off a cliff down to misdemeanors. Usually when that happens, it's because the defendant is going to pay restitution to the victim of this matter, which is myself. And that was, like it's been stated, in amount of $1,591. Thus far, I understand he made a payment today. Up until now, he's paid $155. That is 13 months into being found guilty. That comes out to be $11.92 a month to have felonies dropped, which means it's going to take over 11 years for me, the victim, to recoup my loss on that. I would ask the court, and I understand that Mr. Gahn wants to say that he only has a limited income. But first of all, where's the punishment? And more importantly, where's the justice for the victim in that? 11 years I have to wait to recoup my loss. Furthermore, I appreciate you saying that you want to see his income. I would also ask the court, require him to restate his outgoing income. Yes, since April, his current living conditions have changed. He has not had to make a mortgage/rent payment. That'll be decided by a court later on in future proceedings. So he's had a significant drop in outgoing payments, and I know this personally because I'm involved in purchasing the property that he lives in since April, with no increase of payments to the court, but an increase of income. So I ask that the court take that into consideration and ask him to provide proof of that information as well. And lastly, Your Honor, being a snowbird, I request that I can be a part of the next set hearing by Zoom. So I don't have to drive 2,000 miles up here if that appeases you. Other than that, thank you very much for your time.
Yeah, I mean, I'm always willing to allow you to appear remotely, like to do that.
Thank you.
I don't have any objection to that. So I just want to take a short break. I want to look at a couple other things from the file, so I'm just gonna ask everybody just to remain here for just a moment. Okay. Mr.
Your
Thompson,
Honor.
go ahead.
Yeah, the one thing I wanted to add, just in terms of the next hearing, this would be Mr. Garamuthi's case, and I'm covering for him today.
That's right. Okay, thank you.
All right.
All right, one. We're back in the record. I just wanted to go,
There he is.
check the file to see the restitution amounts that were ordered. So Mr. Gagoski, I mean, I certainly understand your frustration with the process. The only thing that I can say, number one, is restitution orders are enforceable in a lot of different ways. They're enforceable as civil judgments. So, I mean, you could take action on your own to over and above what the court's doing to try to collect. Ms. Koch's office through the Crime Victims' Rights Act has the ability to enforce judgments of restitution. So, you know, you can feel free to consult her office because under the statute, the prosecutor can take action to enforce as well. In terms of the charges and where they ended up, you know, I'm not trying to throw the blame on Ms. Koch, but I mean, the court's job here was to sentence based on the charges that Mr. Gunn pled to. So
Yes, Your
that stuff all took place, so. And I know that sounds like I'm throwing all the responsibility on Ms. Koch, which the court has a responsibility to enforce its own orders as well. But there are other mechanisms available to the extent that the limitations that I have in terms of requiring Mr. Gunn to pay amounts and what amounts. There are other mechanisms that can be used in addition to that. So I would encourage you, you know, number one, to talk to Ms. Koch to see what resources are available to the prosecutor's office under the Crime Victims' Rights Act to further seek amounts for restitution. So that, to the extent that that's helpful.
I do have a question. Could we, because restitution normally takes precedence, can we make all the payments go to the restitution versus the PPO fines first? Because what's happening is he's making payments and they're going to the court fines and they're going on that PPO case, which I'm not involved in, and they're going to restitution. Can we just hold off on those court fines and do restitution until that's paid?
It's got to be applied to whatever amounts are paid to which file. So the restitution does get paid, any amounts that go to the criminal file, it goes to restitution first before anything else.
I have a
So
question.
what Ms. I think what Ms. Koch is saying, instead of paying on the if there's $50 and it's being split $25 on the PPO and the felony file, is that $50 gets solely applied to the felony case under restitution only.
Yeah, we can certainly do that.
I mean, that will,
It started that way, and then you made a ruling off the bench that the payments were to go to both the PPO and the felony file. I can take the money and put it in whichever file it is. I just need to know how you want to proceed with
Are the
it.
PPO monies all going to the court fines and costs? Is any of that related to any kind of payments to Mr. Gagoski?
No, it's a penal fine, so it's coming to the court.
So then I'm going to order that all payments until the restitution is satisfied, all payments be applied to that file.
thank you.
Your Honor. Bill's right. I don't make no house payments no more because I own the house. I paid it off. So it has freed up some money. That is a tremendous weight off of me because now I'm able to feed the children without trying to scrape for food. I believe I would be able to give $50 a month on each. Well, you're doing it all in one. I should be able to make $100 a month payment. Because I made 50, but I split it between the two. If they're gonna put it all on one, then that would be $100. Because I think I could do 50 on both each month.
Well, I'm ordering you to pay as much as you can.
Right. No, I can't. I could do that.
Yeah.
Because I was looking at that yesterday.
And then the next time we're here, we're gonna look at your bank statements and see
Roger
where
that.
that lines up with.
Yes, ma'am. Or yes, ma'am.
Okay.
Okay.
All right. Thank you. That's all for today.
Thank you, Your Honor.
Have a good weekend, y'all.
Mr. Thompson, you're free to disconnect at this time. See that.
Just yesterday.
All right,
The guy in the bottom is Mr. Colin. Craig Colin.
oh, Mr. Collin.
Yep.
All right, Mr. Collin, we've got one hearing before yours, so I'm just gonna put you in the waiting room for a moment.
Okay.
All right, and Mr. Hewitt and Mr. Carey, if you can both unmute, please.
There we go.
Great, thank you. We'll go on the record in Shaw versus Stiles, case number 2311441. And if I could have both counsel, please put your appearances on the record.
Yes, good afternoon. On behalf of the plaintiff is Charles Hewitt, Your Honor.
Good afternoon, Your Honor. Dean Carey, appearing on behalf of defendant Stiles.
All right, thank you. This is set for a status conference today. I'm not sure how far along in this matter we are. On behalf of plaintiff, Mr. Hewitt, can you tell me the status from your side of things?
Be happy to, Your Honor. Back on July 25th, we attempted mediation with Mr. Hess and Roscommon. Unfortunately, we're not able to find a resolution. Thereafter, upon request of Mr. Carey, we allowed him to file a motion to get an order to allow him to amend his pleadings, and he's filed a counter complaint. I think it was yesterday, right, Mr. Carey? We talked with Mr. Carey and myself, and we had figured out we probably have 4 depositions to take, so we're back on a pretrial process, if you will.
Okay, Mr. Carey, anything new, different that you wanted to add to that?
No, I think that's all accurate. I do think we had a relatively productive call that could lead to some settlement, further settlement discussions post-mediation. I think Mr. Hewitt is going to be filing his answer to our counterclaim. We don't have, and we don't have any, no issues there. But we did, because we have a couple of depositions that may seem likely. I was looking at the file. It looks like discovery closed in this matter back in April. And just since we have you here now, we were hoping to extend discovery an additional 90 days, just so we can get the 3 depositions that our 2 offices discussed yesterday. And that I think will be the only additional discovery, but we were hoping, just to be safe, an additional 90 days extension on that, if that's all right.
So do either of you think that the information that you get from those depositions is gonna lead to wanting to take another stab at mediation, or do we just want to enter a new discovery cutoff date, maybe a cutoff date for dispositive motions, and then go from there?
Well, Judge, I'm not sure that this case lends itself to dispositive motions because factual questions about who is doing what. I think the court has a good point. The depositions we're going to take would be of the respective owners and then one of the defendant's counterplaintiff's predecessors in title to see whether or not that person prescriptively used this driveway in question at all. Once we get through those, I think more so than maybe given a path to a summary disposition, it might well better give a path to a resolution. For example, if either one of us thinks we can't support our claim. We could conceivably want mediation again, but as Mr. Carey pointed out, there were some discussions yesterday about a potential resolution. I've not yet had a chance to talk to my client. Hasn't quite been 24 hours yet, but I intend to do that pretty soon.
And I would only add, I think that's all perfect, exactly accurate. I think maybe resolution discussions between counsel in an informal setting may be more productive in this case than informal mediation with the clients across the table. I don't know if Mr. Hewitt agrees, but I don't know that we would want to set another mediation schedule in addition to the additional discovery. Just my thoughts.
Yeah, I would agree with that. For the time being, I would agree with that. Yeah, I don't think it's necessary for a formal mediation, no.
All right, so why don't we do this? I'm gonna, as part of the status conference order today, I'm gonna order that discoveries to remain open for additional 90 days. I will set this for another status conference at the expiration of that time frame by Zoom, just like we're doing today. I'd like to see where the parties are at. If you want to continue with potential mediation again, at that point, we can build in some time for that. And we can look at setting dates for, has there been a jury demand? Is this going to go to this were to go to trial, is this jury or before the bench?
Bench trial, right?
Yeah, purely bench trial, Your Honor.
Okay, so at that status conference at 90 days, if the parties still want to work on resolution, we can build time into that and then get a date on the calendar for a bench trial so that we have an end date that everybody's working towards. And I think once you get those depositions done, it might help us figure out how much time we want to build in for that. So, Mr. Hewitt, do you have any objection to going forward that way?
No, I think that's appropriate. It's a good use of the court's time.
All right. Mr. Carey, do you have any objection?
No objections.
Okay. All right, anything else that I can address for either of you while we're on the record today?
Not from us. No, Your Honor, thanks.
Thank you, Your Honor.
Okay, thank you. I'll put that into an order. The court will also send out a notice of a date and time for that next status conference, and you're both free to disconnect.
All right, thank you, Judge.
Thanks.
See you, Dave.
All right, Mr. Colin, are you able to hear me okay?
Yes, sir.
Mr. Vernon, are you able to hear me all right?
Yes, Your Honor. Can you hear us?
Yeah, okay, so we're on the record in Colin versus Colin, case number 2411622. The record should reflect that all parties are present today, along with Mr. Vernon on behalf of his client, all by Zoom. We did have two things docketed for today. One was a motion to adjourn a hearing. I believe the parties stipulated to move that. So I don't think that's an issue. So it's just a matter of a status conference, and Mr. Vernon, on behalf of your client, can you tell me the status of the case in terms of the marital assets and property division aspect of this?
So, yeah, we've got a pending custody parenting time evidentiary hearing going on, which will come before you on Mr. Collins' objection to the temporary order from the referee. Judge Burmeister had heard the first half of that. That second half of that's going to be is scheduled in front of you. With regard to property division and the divorce, we've had mediation. We were unsuccessful. We're likely going to be scheduling that for trial. So I suspect that at some point we're going to be scheduling a trial date with regard to both custody and division of property.
All right. Mr. Colin, do you agree with that in terms of how you see this going forward?
Yes, Your Honor.
Okay. Mr. Vernon, do you have any objection to, I mean, I know we've already got a hearing scheduled for October, I believe, on the custody and support parenting time issues. to the extent that further hearings are necessary after that, do you have any objection to setting both the property and any issues related to minor children together?
No,
Are you
together, fine. Yeah,
Mr. Colin?
Can you restate that, Your Honor?
Yeah, instead of having separate, I mean, we're gonna go forward with the hearing that's currently scheduled in October, but beyond that, do you have any objection, instead of setting separate hearings to address issues related to the minor children, and then separate hearings for issues related to the division of your marital assets or debts or property? Do you have any objection to having those hearings together so that we could streamline things a little bit?
I don't see why they need to be together, because wouldn't the 14th of October be the final? That's what Teresa Hill stated. But it could not be.
And it very well may be the final hearing as to those issues. I don't know. I don't know what's going to happen on the 14th.
Okay. No, I have no objections then, Your Honor. That's fine. I'm ready to move forward faster.
Okay. All right. So let's proceed with the hearing as scheduled in October. Let's see where we're at the close of that hearing, and then the court will conduct further scheduling as needed with regard to both the property issues and issues related to minor children, if further hearings are necessary on that. Mr. Vernon, anything else I can address for your side here today?
just the one logistical question that popped up. If there are new issues that come up related to the children, I assume we're still filing those with front of the court, and then they will simply schedule them with you?
Right, correct.
Oh.
Mr. Colin, did you have any questions?
Just that the 14th of October is still with Teresa Hill and not with you,
I'm not sure who that's in front of.
the referee. I was just wondering because if we were going to converge the rest of them, they'd be with you, but with the 14th scheduled with Teresa, then that wouldn't be with you. I'm just verifying.
October 14th at 1 o'clock is with front of the court.
Okay.
Okay. I guess I misunderstood, Mr. Vernon. I thought you said that the hearing on the 14th was in front of me.
I thought it was. I thought because the evidentiary hearing we're having was in front of Judge Burmeister. The objection on Mr. Collins's objection to the temporary order entered by the friend of the court. So I would assume we'd have to finish that in front of Judge Burmeister, now you, before friend of the court could make any other temporary orders. So that confuses me too.
Just a moment.
Burmeister only sequestered himself from the PPO hearing and the divorce, not the custody. He wasn't a part of the custody yet.
Okay. I have a stip in order to adjourn the 9/11 date at 1 until October 14th at 1 o'clock. This order also does not specify if this is in front of the judge or in front of the court. Yesterday, Mr. Colin came in and filed a motion in front of judge for a 9/16 at 3:15 and a front of the court motion for custody that is scheduled at 10:14 at 1 o'clock. So I am assuming that 10:14 at 1 is with front of the court, as our court typically doesn't convene at 1.
Okay.
And the 14th would be a Monday.
All right, so we're going to proceed with each of these matters as they're currently scheduled, and we'll see where we end up.
Yeah, thank you.
Okay. All right, thank you. That's all for today. All parties are free to disconnect at this time.
Judge, I'm not going to disconnect because I think I have the next one.
Yes, okay, yep.
Okay.
Sounds good. If you want to get your
Give
clock.
me just, yeah, give me a second to step out.
Certainly.
Press leave or, Your Honor?
Mr. Colin, you're free to disconnect. Yeah, I'm
Okay.
moving on to the next
Okay,
file.
thank you.
Thank you.
You're welcome.
Yeah. I'll wait for you. This will make sure we- I'll let you write it down.
Some of those days, I don't think it's from the court judge, because I have a hearing set, but everybody, I'm like, okay, wait a minute.
So you can see the judge can see us.
Okay.
And
All right, we're ready to go forward.
I
This
need
is
1 second
Crawford
to get the
versus-
file.
What's that?
I need 1 second to get the file. My secretary
Okay.
can give it to me right now.
All right, I'm still gonna go on the record. This is
Okay.
Koth versus Koth, case number 24-11670. The record should reflect that the plaintiff is present with her counsel, Mr. Vernon, by Zoom video. This matter was set for hearing at 2 p.m. It's now 2:08 by my clock. Mr. Koth has not appeared either in person here in the courtroom or in the Zoom waiting room. This is set for entry of a default judgment of divorce today. I do want to note for the record that Mr. Koth was properly served with the summons and complaint. That he did not file any type of answer or otherwise defend that he was defaulted back on June 24th. And that he was provided with notice of the date and time of today's hearing. Again, he has not appeared. So I think we can go forward today. Mr. Vernon, did you want to take proofs from your client?
Yes, Your Honor.
Okay, ma'am, if you could raise your right hand, please. Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth to help you God?
Yes, I do.
Thank you. You can lower your hand. And Mr. Vernon, go ahead and proceed with your questions. If you can have Ms. Koth speak up or move the mic closer to her. Her voice is a little bit faint.
Okay. Can you hear us better now, Judge?
Thank you.
Okay. State your name.
Ramona Charlene House.
And are you married to William Couth?
Yes.
And we filed a complaint for divorce. And did you read that complaint for divorce prior to signing it?
Yes.
And were all the facts and circumstances set forth in that complaint true when you signed it?
Yes.
Were you?
Mr. Vernon, I'm sorry to interrupt, but you're breaking up quite a bit, and I'm only getting about a third of what you're saying there.
I was looking down, so maybe if I look up a little bit, that'll be easier. Can you hear me better?
No, and it's like a connection issue more than a microphone issue at this point.
I don't know where the microphone is. That's not on, is it? It's not causing us trouble. Okay. I did. Let me see. Hold on 1 second. How do we do that thing with the?
I think it's starting to come through better now. Maybe that was just a glitch in the system or something. Let's try it again.
Okay. I'm gonna back up then a little bit. All the terms set forth in the complaint, you reviewed those before you signed the complaint?
Yes, I did.
And were those true when you signed it?
Yes, they
Are
were.
they still true today?
Yes.
Okay. Were you a resident of Crawford County for 10 days prior to the filing of that complaint?
Yes.
Were you a resident of the state of Michigan for 180 days prior to the filing of that complaint?
Yes.
Okay. Are you pregnant?
No.
Okay. The division of property that we set forth in the proposed consent judgment, you reviewed that?
Yes.
And you believe that to be a fair and equitable division of the property?
Yes.
You understand that you are limited to, just want to pull up the language on the first, spousal support, that you are waiving any claim to spousal support?
Yes.
And that you can't come back later and determine and ask the court to grant you spousal support later?
Yes.
Okay. And then was it your request to restore your maiden name?
Yes,
Okay, and your maiden name was McMillan,
yes,
and that is spelled McMillan?
yes.
Okay. Has there been a breakdown in the marital relationship to the extent that the bonds of matrimony can no longer be achieved?
Yes,
Okay, is there any likelihood of fixing that?
no,
Okay, do you know where Mr. Health lives now?
only according to the paperwork that you sent, that's the only way I know.
When was the last time you had any contact with him?
Oh, I've been here almost 3 years now,
So at least 3 years?
at least 3 years.
Okay, and has he made any attempts to contact you?
No,
Have you made any attempts to contact him?
no,
Okay, Judge, I think we satisfied the statutory requirements, and I think the proofs for a default and entry of that default are appropriate. We'd ask the court to accept them.
Thank you. The court has heard the testimony of Ms. Kaut. The court finds that her testimony does meet the statutory grounds for divorce. The court's reviewed the proposed judgment and finds that it's generally equitable and contains all the provisions required by statute and court rule. The court will grant the divorce, and I've signed that judgment with today's date. Mr. Vernon, anything else I can address for you on this file today?
No, Your Honor.
Okay. All right. Thank you. You're free to disconnect at this time.
You know, I do have one question. Do you want us to send a copy of the signed consent judgment to Mr. Kauth at the address we have on file? Or is the court gonna do that?
That is something that you would be your responsibility if you wanted to do that.
We'll get that done then. Thank you.
All right. Thank you.
You are.
Mr. Leonardson, are you able to hear me okay?
Yes, I am.
All right, and Mr. Thompson?
Yes, Your Honor, thank you. Jason Thompson on behalf of the plaintiff, Katie Copperno.
Okay, we're on the record in Coppernell versus Patrocino. This is case number 2311369. The record should reflect both counsel are present by Zoom video. It looks like both parties are signed in as well. Mr. Leonardson, you filed a motion. I did read your motion and your response, Mr. Thompson. Mr. Leonardson, was there anything you wanted to say by way of our oral argument here today?
Well, it's difficult that we're here. There was a judgment entered and I received a copy of it. And I'm doing it because there's a time element. But what all that was requested was a payment to the plaintiff for $11,000 and that she would sign off on the mortgage. She refuses to sign a quitclaim deed, even to hold that at her counsel. What needs to be done is there was an application for assuming the mortgage. Because both parties are listed on the mortgage, both parties must sign that application. The application is for my client to assume the mortgage under her name. That would relieve the plaintiff from any suit against from the bank. So all that really has to be done is the plaintiff has to sign the application for refinance. My client has a formal application. She's prepared 3 times to enter to the lender for consideration. Once they agree to the loan assumption, then there would be a release of $11,000 in exchange for a quitclaim deed. I believe that's all that's got to be done. But the plaintiff and counsel have made it difficult and impossible to proceed. The original judgment by the court was that my client was to pay the plaintiff $11,000 and remove her from the mortgage by October 4th. That probably can't be done because of the time sequence. During that 5 months, the plaintiff has refused on several opportunities to sign a quitclaim deed and be reimbursed $11,000. My client is willing to pay $11,000 to the client this time, although she feels she's gotten jacked around and would like to renegotiate. She will settle for $11,000 with a signing of the application and the quitclaim deed. Her counsel can hold the quitclaim deed until there's verification that she's been approved by the mortgage if they wish, but that hasn't even been requested. We've been trying to resolve this for over a year. We're asking the court intervention, number one, to go with the judgment, but to modify the October 4th date because of the inability to get cooperation by the plaintiff. Number two, the plaintiff is ordered to sign the application, and my client will sign the quitclaim deed upon or my client will pay $11,000 even in her attorney's trust account upon receiving a quitclaim deed from the plaintiff. That should wrap up the case. I don't know what else to say. I was a real estate broker for 2 decades. I've never, I never had this problem as a salesperson or as an attorney. it can be resolved very quickly. What the plaintiff is saying is she will only accept it on a refinance. A refinance would be at the pleasure of my client, but it would cost her approximately 7% interest in additional payments. It's not necessary when she can assume the mortgage and remove the plaintiff from the mortgage. It's very simple. I don't know why we're having the problem. That's my argument.
Okay, well, maybe Mr. Thompson, can you tell us where the problem is here from your standpoint?
Yeah, Your Honor. We did receive this motion when it was first filed, asking for a quitclaim deed. I mean, the first request they made was that the defendant agree to indemnify the plaintiff on the mortgage, which is obviously very inferior to coming off a mortgage. They then asked her to sign an application for an assumption, and her response, which I think makes perfect sense, is she'll participate when they show that she's got the funds in escrow. And when the bank confirms that if this process went through, she would be relieved of all liability on the mortgage. Neither of those things has happened, so she hasn't signed a quitclaim deed because there'd be no reason for her to yet. If they take her off the mortgage to where she has absolutely no liability on it and pay her $11,000, then they're entitled to their deed.
Okay, so how is that? I guess what I'm trying to understand, Mr. Leonardson's indicating that he's asking, that he's saying that all your client needs to do is sign, or I guess, I don't know, Mr. Leonardson, when you say you need Mr. Thompson's client to sign an application, what are you talking about an application for?
To proceed with the loan assumption. Carlton Mortgage, it's a Carlton Mortgage form, and it just indicates that the homeowners, they've read it and that they agree and wish to proceed. That's all it is. It's an acknowledgement of the owners. And at this time, there are two owners. They have, in order to process the assumption, this form has to be filled out and delivered. It was signed on 5/12 and 6/18, and I believe one time before that by my client. Once that's done, the assumption proceeds, and upon receiving an acknowledgement from the lender that she has assumed the mortgage, a quick claim can be entered. A quick claim can be entered upon receiving $11,000, which my client has always been prepared to perform on. So there's
all right. So Mr. Thompson, my question to you is, and I get your argument, Mr. Thompson, about an assumption of risk or something like that is not adequate protection for your client, but it sounds like Mr. Leonardson's talking about something different.
No, Your Honor, assuming the payments is one thing, but releasing my client from liability is what she's been after the whole time. I mean, she signed on to this mortgage. She's on the hook for this $100,000 mortgage, call it. She wants off the mortgage and off the property. Assuming the mortgage doesn't release her from the liability, and no one's given us anything from the bank that says if this assumption goes through, Katie Coppernow will be released of all liability on this mortgage. That's what she needs to be able to go and buy her own house, which is her ultimate goal on this. She took far less than half of the market equity on this, the 11,000. She wants off of it, and she wants a complete release, and nobody has made provision for that. Assumption of the mortgage is not the exact same as release of her liability of it.
The mortgage would be assumed in my client's name only, and the documents of the assumption would make my client totally 100% liable. we're willing to give copies of that to them, but we're not going to proceed. And the question gets down to whether she would issue a quick claim deed. And either she's been instructed by our attorney not to, or she's decided herself not to. That's not acceptable. My client will formally assume, I mean, I don't know what the question is. My client will formally assume the mortgage in her name only. And we will supply documents once those are completed to your client. In return for that, we will also pay her $11,000, and we're asking for a quitclaim deed from her, releasing any interest she might have in the property. What's so complicated about that?
Well, I think we're talking about two different things, because what the judgment says is defendant will tender to plaintiff $11,000 and remove plaintiff from the mortgage. It doesn't say and assume the mortgage.
Right.
You know, it says remove plaintiff from the mortgage. So if Ms. Coppernall's name is going to remain in the chain of title recorded as part of the mortgage, then I guess that's a problem. If it's not, then it's not. So
it's a
I'm not familiar with assumption of a mortgage. I'm familiar with refinancing where the loan gets changed into the other person's name and the original person who's on it is no longer liable for the debt under the mortgage. But I don't know if an assumption of the mortgage has that same effect.
May I
And
speak, Your Honor?
Mr. Thompson is saying that it doesn't.
Well, that's crazy. That's crazy talk. I mean, it's a formal assumption.
Well, somebody's going to have to show me something then, because one of you is saying one thing and the other is saying the other, and I don't have any authority from either one. And respectfully, I see the clients raising their hands, and I appreciate both of whatever the two of you might add to this, but it's really a legal question, and the lawyers should be able to answer this. And all you both of the attorneys have done so far is just tell me what they think, and nobody's showing me any law to support their argument one way or the other. Mr. Leonardson's saying that this assumption of mortgage would have the same effect as removing the plaintiff from the mortgage. Mr. Thompson saying that it doesn't. So that doesn't help me out at all. I can't just say I agree with one or the other of you without having some legal basis to do that, and nobody's given me that. So at this point, I'm going to deny the motion. The judgment says what it says. And until somebody can provide me with some authority one way or the other, there's nothing else I can do. So.
Okay, for clarification, you are asking, will a letter from the mortgage company saying that the loan assumption will relieve the plaintiff from the debt? Will that suffice for the court? What will suffice?
I mean, that would help.
And what about the check? I would like proof that she's going to, I want the check first before I sign off on the house and just give her that house. A quitclaim deed is different than refinancing. If she refinances the house, I'm guaranteed my money and I'm completely off the mortgage. And that's what the judgment says. And that's what I'd like to be followed.
All right, well, here's the thing. There's no reason why both of your clients can't execute checks, execute documents, and put them into the possession of the lawyers who can't ethically do anything with those until this matter is concluded. So there's no reason why both of you can't have your clients execute what needs to be executed. The lawyers hold that, and then we wrangle the legal part of it, and then everybody goes along their way. But there should be no reason why either side is claiming that somebody won't do what they're supposed to do. Because there's no reason why checks can't be written, placed into escrow or into lawyers' trust accounts. There's no reason why documents can't be executed and kept in the lawyer's file until it's time to exchange everything. So if everybody does that, then the only question is, the legal part of what is sufficient. So either way, there isn't anything else I can do today. The lawyers are gonna have to go to work on this, and I've got to move on to my next case. So this case is, again, the motion is denied as presented. I'm happy to hear further argument once somebody provides some authority to me. But that's all in this hearing for today.
Thank you.
Thank you,
Adam.
Your Honor.
Good afternoon.
Hello, just one second here. I've got a few people signing in. All right. Okay, we're on the record now in Bodet versus Reedy, case number 2311562. Looks like we have Mr. Bodet is connected by Zoom, as is Mr. Friel and Mr. Menkes. We're all on the record here for yet another status conference in a series of status conferences. And I'm hoping that we'll be able to address something today. Hold on one second before we get started. Ma'am, on the Motorola device, can you unmute and tell me your name, please?
My name is Cynthia Elkhorn.
Okay, ma'am, I'm gonna put you back in the waiting room. This is a different proceeding, and when I call that case, I'll bring you back in. Okay, Mr. Bodet, from your side, can you tell me, has anything been accomplished over the last 30 days? I see that you haven't had an attorney file an appearance on your behalf.
No, Judge, after you put us in our meeting room after the last proceedings, myself and the two attorneys for the defendants discussed what my situation was and what it was that we were trying to achieve from moving forward. I did reach out to counsel, friends of ours that tried to craft up a letter. Unfortunately, a rather long 2-week vacation of theirs got in the way, and things got misconstrued, and they unfortunately didn't come through with paperwork until yesterday, or day before yesterday for that matter. And I was able to send that to Mr. Friel. I sent it out to both of the attorneys, and I apologize for the late notice. Unfortunately, it was something that happened. It was a little bit out of my control, even though I prodded the counsel of mine to get it to me. They unfortunately dragged their feet through a vacation to get it to me. But it's pretty, I think, if I'm not sure if Mr. Menkes has had a chance to look at it. I sent it directly to Mr. Friel. I understand Mr. Menkes is in and out with this, as far as his situation right now, as far as retirement goes. But my wife and I essentially are not asking for anything major. We're asking for very, they're not demands. We took the term demands out of everything, and we put, requests, that this is not something that we're looking, to draw out. We're asking for just to be left alone, basically, and get our privacy back. And it appears that that Mr. Reedy has a problem with that. I'm not exactly sure why, and this stems from something that happened close to 2 years ago now. And for some reason, he seems to latch onto this and continues to keep his antics up. And I'm not exactly sure why.
All right, Mr. Menkes?
Yeah, Judge, I just received one of the few things today I agree with Mr. Bodet on is, and I just received this morning and at home on my email, and it is entitled requests, not demands. However, there's 11 paragraphs of things, the majority of which, in my opinion, have no place in civil litigation. They're more the subject of a PPO. And All 11 apply to William Reedy, Mr. Friedel's client. The only one that applies to me apparently is paragraph number 9. Adherence to township restrictions. Mr. William Reedy and his brother Steve Reedy, I don't know who Steve Reedy is. David is my client. I'm assuming that's a typo. And his brother Steve Reedy are not allowed on township property due to documented and recorded threats made towards Sandy in a December 2021 meeting. This restriction must be enforced. That is nothing short of outrageous, outrageous. And when the court, I don't know if the court will ever see of these, so many of these others are, in my opinion, outrageous and not subject to the court's jurisdiction or a jury's jurisdiction. But because all of them apply to William Reedy, Mr. Friedel's client, I will let him take the wheel now.
All right, Mr. Friel.
I'll just play good cop, bad cop today. I got this last night. I appreciate plaintiff's reasons for the last minute submission. I have forwarded to my client. I agree with Mr. Menke's characterization. However, I also enjoy a challenge. So we're going to see if we can work something out that gets the case dismissed. My suggestion to the court would be, in the meantime, to conduct a normal scheduling conference so we can get some dates going. That doesn't mean that we can't keep talking. In fact, that would be normal in any other lawsuit. But I was able to speak with my client this morning. I believe he's watching. He may be watching right now. And incidentally, he did not share any video, just for the records, as that was brought up last month. But yeah, we're going to keep a positive attitude and try to get something worked out that results in a dismissal.
Okay. All right. So I guess, Mr. Bodet, I put this question to you before, and I guess I'm going to put it to you again, because I agree with Mr. Friel. I think at this point, the proper procedure for the court to follow would be to set scheduling dates and move forward with the case. And that's what I intend to do, unless you tell me that you're not going to go forward with the case. So, your choices at this point are, again, I'll set scheduling dates. We'll go forward. You can either represent yourself or you can hire an attorney. That's up to you. You're free to do either of those things. The one thing you can't do is nothing. You're the plaintiff in the case, and it's your obligation, to the extent that you have wrongs that you're seeking to have redressed. It's your obligation in the law to pursue that. And to the extent you don't, then the court would likely just end up dismissing your claims. But outside of that, I'm more than happy to set scheduling and move forward with the case so that you can seek redress of what you claim has been done wrong. So, I mean, I guess, but I'm not going to do that if you're going to tell me today that you're not going to move forward with the case. So do you wish to move forward with your case at this point?
At this point, Your Honor, yes. Because we've got these requests, I'm unfortunately going to have to move forward with this. We're not asking for the moon. We're asking for just, common neighborly, issues to be resolved. And it appears that we're going to have to move further forward if that's going to be in effect. I mean, I'm open to, taking this to moderation rather than take up the court's time. I'm not sure if that's something that's available or not, but it's definitely something that I'm open to.
Okay. All right. So what I'm going to do is I'm going to have 90 days for discovery. The court is going to also set a dispositive motion cutoff at about 90 days. So to the extent that either the defendants want to file any type of dispositive motion, that would need to be filed and set for hearing within the next 90 days. And then the court would, Mr. Friel or Mr. Menkes, are either of you contemplating that, or is that something that you're going to contemplate filing within that time frame?
Judge, quite frankly, I think for a legitimate dispositive motion to be filed, some discovery is going to have to be undertaken, and probably in the form of sworn testimony at depositions, because without that, I don't think the court has enough to grant a motion one way or the other. So 90 days, I don't know if that's going to be adequate, but I think that quite frankly, once the necessary discovery is completed, we will be in a position to file at least a motion for partial, if not total.
Okay, how much time do you think you're gonna need for discovery then?
I would suggest 120 days.
Okay.
And of course, some of that may be dependent upon whether Mr. Bodet hires counsel. Things will move along much more expeditiously under the court rules than if Mr. Bodet is representing himself, but I guess that remains to be seen. So I think at this point, we should probably set it at 120. But like Mr. Friedel said, we can continue with the settlement negotiations. And I'm sure that probably Mr. Bodet, either alone or with the help of counsel, will pare down his so-called request. So all is not lost at this point in that regard.
Okay, all right, so I'll set it for 120 days of discovery. The court will set that dispositive motion cutoff 30 days following the close of discovery. That way, if they're C10 type motions, which are based on factual discrepancies, Mr. Bodet, then parties will have time to complete discovery and then file any dispositive motions. And then the court will, Mr. Bodet mentioned mediation. Does counsel have any objection to participating in mediation during that time frame?
Judge, I would have no objection to the court putting in standard form language into your order in terms of mediation. We're always in favor of mediation.
Okay, Mr. Friel, any objection to that?
I agree, and I think the bigger picture too, for long-term sustenance of any result, it's going to be better to have facilitative mediation than something like case evaluation.
Okay, so the
But have
court will
something
order.
that lasts.
Sure. The court will order that mediation occur then within that time for discovery, so within the next 120 days, which is the court standard order. And then I will set this for another status conference following the dispositive motion cutoff. Obviously, if the parties have been able to reach an agreement either through mediation or otherwise by then, we won't need any of those hearings, but otherwise that'll give us the next date to see where things are at. And I will put all of those dates into an order. I will get that out to the parties along with a notice of the date and time of that next status conference. Mr. Bodet, do you have any questions at all?
Not today, Your Honor. Thank you.
Okay. Mr. Mackey, anything further from your side?
No, thanks, Judge. I think we're all set.
Okay, Mr. Friel?
I'm good. Everybody have a nice weekend.
You as well.
Okay, thank you. All parties on this file are free to disconnect at this time.
Thank you.
Thank you, Judge.
What matter are you folks here on?
Robert Vineyard.
I'm sorry, what?
Robert Vineyard.
Vineyard, okay. All right, Mr. Blumberg, are you able to hear me okay?
I sure am, Judge. Thank you.
All right, thank you. And ma'am, you said your name was Miss Alcorn, is that correct?
Yeah.
Okay, Mr. Ruckamp, can you hear me?
I can, Your Honor.
Mr. Ruckamp, are you represented by Miss Bailey Quick?
That I am.
And is Miss Alcorn as well?
No.
Okay. Have you had any contact with Miss Bailey Quick? I don't see her signed on to this hearing.
Just by the office, Your Honor. I understood that she had a conflicting or potentially conflicting matter, but she should be able to get on the live stream.
I'm sorry, can you say that again? I wasn't able. Is she going to appear today or no?
My understanding was, yes, she was going to, she had a conflicting matter, but she should be able to get on the stream. I could call right now if you would like.
Are you in the same car with Miss Alcorn?
I am, Your Honor.
Okay, I need one of you guys to disconnect because I'm getting an echo when you have two devices connected.
I can exit or go out of, join her.
I just need one of you to disconnect because I can barely tell what you're saying.
Yes, sir.
Because of the echo. Okay.
Your Honor.
All right, so I'm gonna need to ask you one more time because I really could not hear. Miss Bailey Quick is going to be appearing today?
She is supposed to. If I could have 30 seconds, I will follow up with the office, but she is supposed to be here.
Okay, wait, she is connecting. All right, hold on. All right, Miss Bailey Quick, are you able to hear me okay?
It sounded like she was connecting.
I am, Your Honor.
Okay. All right, we're on the record now in Gadiva versus Ruttkamp and Alcorn. This is case number 2411707. We have Mr. Blumberg connected now on behalf of the plaintiff. And Miss Bailey Quick, are you representing both defendants in this case?
Doesn't matter. Heather G. Rossi versus Daniel G. Rossi, number 44-158. Yeah. Also, if you'd like to start with your case.
You're muted, Miss Bailey Quick. I can't hear you.
And for the record, you have the Rossi.
Yes, sir. No, Your Honor. At this point, I was just representing Mr. Ruttkamp.
Okay. All right, we're on the record today for a scheduling conference in this matter. To set some dates for going forward. Mr. Blumberg, on behalf of the plaintiff, what would you like to see for scheduling to move forward with this case?
Judge, we're going to need to take a number of depositions, including the scriveners that prepared the deed that gave an ownership interest to Mr. Ruttkamp in this property. So I'm thinking maybe 120 days would be appropriate.
I agree.
Okay. 120 days. All right, Miss Alcorn, Mr. Ruttkamp, can you put Miss Alcorn in front of the camera? Miss Alcorn, do you intend to hire an attorney to represent you in this case, or are you going to represent yourself?
I'll likely represent myself.
Okay, do you have any objection to that 120 days for discovery?
No, Your Honor.
All right, Mr. Blumberg, it would be, of course, part of the court's standard order to order mediation within the time for discovery. Do you have any objection to that? And do you think that this is appropriate for community mediation, or do you want to facilitate this?
Well, Judge, the nature of the claims we believe our claim would be subject to mediation. We're asking for money damages as well as an order from the court removing Ms. Alcorn from the property that is jointly owned by my client and Mr. Ruttkamp. The defendant's counter complaint in this matter is one for partition, which I don't think really necessarily subjects itself to mediation.
Okay, Ms. Bailey Quick.
I don't, if the parties do go to mediation, I would request that it be facilitated mediation.
Okay, Mr. Blumberg, do you have any objection to that?
No, that's fine. And I think we probably could agree on Jerry Sheffalo. Both of us have used him in the past.
Okay.
I agree.
All right. Okay, so the court will order that, again, 120 days for discovery. that the parties mediate with Mr. Sheffalo during that period of time for discovery. I will set a dispositive motion cutoff for 30 days after the close of discovery. The parties are free to file any dispositive motions, of course, at any time, but that would be a cutoff date. And then the court would set this for a status conference at about that 120 to 150 day mark to see where things are at that point. Mr. Blumberg, do you have any objection to that?
No, not at all. That seems appropriate.
Ms. Bailey Quick?
I agree.
Ms. Alcorn, do you have any objection to that process going forward?
No, Your Honor.
Okay. So I will put all of those dates into an order. The court will also send out a notice of the date and time of the next status conference. Mr. Blumberg, are there any other dates that I can address for your side today?
I don't believe so. Thank you.
Ms. Ms. Bailey Quick?
No, Your Honor, thank you.
Ms. Alcorn, do you have any questions about how we're going to move forward from here?
No, Your Honor.
Okay. All right, thank you. That's all for this hearing today, and all parties are free to disconnect.
Thank you.
Thank you. Have a great day.
Thank you for that time.
Okay, Ms. Koch, if you wanted to come forward.
Ms. Chady is handling the first two. I'm handling Mr. Vineyard.
I never got any paperwork on that.
This must be Ms. Babbitt. This is the,
Bench warrants.
yes, this is the benchmark, yes.
All right, ma'am, is your name Kimberly Lynn Babbitt?
Yes, sir.
Okay. All right, we're on the record in district court files number 2316848 and 2216666. Both are the people versus Kimberly Lynn Babbitt. Ms. Babbitt is present today by video from the Crawford County Jail.
Dana Chady on behalf of the people, Your Honor.
Thank you, Your Honor. Jason Thompson, Duty Attorney for Kimberly Babbitt. Your Honor, the allegation in this case is that Ms. Babbitt did not appear in court on August 13th for a probation violation hearing. Ms. Babbitt indicated to me that she suffered a seizure that day, went to the emergency room for treatment. So I'm asking the court to enter a not guilty plea on her behalf, have Mr. Garamuthi appointed as her attorney, set a hearing date, and we are asking that she be released on a personal recognizance bond at this time. Thank you.
All right, thank you. What's the people's position as to Mr. Thompson's suggestions there?
Your Honor, the people would be asking just for a small cash bond on this bench warrant. We've had numerous failure to appears from Ms. Babbitt in these cases, some medical, some, intentional. I believe in district court, we're still waiting for documentation on some of those types of appearances. So that's what we'd be requesting. Thank you.
All right, thank you. As to each file, one which is a probation violation file, or are they both probation violation files? Both of them are. The court will enter a not guilty plea with regard to the contempt charges to each file on behalf of Ms. Babbitt. The court will set both of these files for hearing on September 17th at 10:30 a.m. Before Judge Burmeister. The court will set bond in each file at $50 cash bond in each file. So a total of $100 and all standard conditions of bond as well as all conditions of probation to remain in effect pending that hearing on September 17th. Mr. Thompson, anything further from your side on each of these files today?
No, Your Honor, thank you.
The people have anything further on either of these?
No, Your Honor, thank you.
All right. Thank you. That's all for today. That's all for Ms. Babbitt. If we could have Mr. Vineyard brought into the booking room, please.
I'm not getting out today.
Thank you.
Yeah.
All right, sir, is your name Robert Lee Vineyard?
Yes, it's Robert Lee Vineyard.
All right, we're on the record now in Crawford County District Court file number 2417614 FY, People versus Robert Vineyard. The record should reflect that Mr. Vineyard is present today by video from the Crawford County Jail. If I could have counsel put your appearances on.
Sierra Coke on behalf of the people.
Thank you, Your Honor. Jason Thompson, duty attorney for Robert Vineyard today. Your Honor, Mr. Vineyard would waive a formal reading of the complaint, but ask the court to enter a not guilty plea on his behalf. He is requesting his preliminary examination be held within 21 days. He intends to retain his own attorney, and we are prepared to address bond whenever the court is ready for that time. Thank you.
All right, the court will enter a not guilty plea on behalf of Mr. Vineyard with regard to all 5 counts in this case. And the court will set this for hearing. I don't have that hearing date right with me, but the district court will provide that to counsel and to Mr. Vineyard with regard to the felony pretrial and the preliminary examination and probable cause conference. In terms of bond pending that next felony pretrial hearing, Ms. Coke, do people take any positions?
Your Honor, based on the seriousness of the charges, the protection of the public, he has no criminal history. He does, however, have multiple homes. I listened to all of his jail calls with the victim, which is where he met the victim, who was 19. He told the victim in that case that he had 5 houses between here and Florida that were unoccupied that they could just stop at. He referenced multiple properties, including properties in Florida where he indicated he was a resident. So I do have some concerns about that. Throughout those calls, he referenced his net worth numerous times, which I believe is high. He has the ability to flee. We would ask for a high cash bond in the amount of $200,000 without 10%. Thank you.
Thank you, Mr. Thompson.
Thank you, Your Honor. Mr. Vineyard has lived in the community since 1989. He does own real estate in this community, so he's tied to the community, and the court does have mechanisms, you know, in the event of some sort of non-appearance to try to collect on bonds and things like that. But he has family in the community. He's never had a felony, never had a failure to appear. He's not on probation or parole, never been convicted of a misdemeanor. I think a $30,000 bond with a 10% cash option, you know, if he's spending his own money on this, I think he's invested in the case. And again, the court can, you know, he has strong ties to the community and asked the court to consider a $30,000 bond with a 10% option. Thank you.
All right, thank you. Looking at the seriousness of the charges in this case, Mr. Vineyard is charged with 5 separate counts of criminal sexual conduct. So we're dealing with assaulted crimes, which in and of themselves are serious. They do allege sexual penetrations using force or coercion to accomplish those penetrations in each of the counts. The maximum possible penalty for each of those counts is up to 15 years. So we're dealing with a significant potential penalty if Mr. Vineyard is eventually found guilty of any or all of those charges. The court finds, based on the information provided by the prosecutor, that there is a concern regarding, although Mr. Vineyard does have substantial ties with the community and has lived here for a long time, that due to his ownership of various properties, that he may try to flee the jurisdiction. So the court does have concerns that a lower bond will not ensure Mr. Vineyard's appearance at future hearings. So The court finds for all those factors, there are concerns given or with regard to both public safety and his appearance at future hearings. The court finds that a high bond is appropriate. The court is going to set bond in the amount of $200,000. Cash or surety as recommended by the people. I find that that amount is necessary both to protect the safety of the public and to ensure his appearances. So the court will set bond in that amount. The court will include all the standard terms and conditions of bond. The court will also include as conditions that the defendant not have any contact with the victim in this case. I'm not going to state the name here, but it's listed in the bond paperwork. Not have any direct or indirect contact with the victim. If he does post bond, to be in any areas where the victim is, and to not assault, harass, intimidate, or otherwise threaten the victim in this case. That'll be spelled out in the bond paperwork.
Judge, on a side note, the paperwork in the district court file does have the next set of court dates in there.
Oh, there we go. All right, not used to the paperwork in the district court files. So those dates that I indicated earlier, September 17th at 1 p.m. will be the felony pretrial. October 8th at 2 p.m. will be the preliminary exam. And again, both counsel and Mr. Vineyard will be provided with written notice of those dates.
And Your Honor, this may be speculative, but if Mr. Vineyard did wish to post unencumbered real estate, that would be by motion in front of the district court judge, correct?
Yes.
All right. Thank you, Your Honor. Mr. Vineyard, if you want to explore posting real estate for your bond, that would be by motion in front of the district court judge.
Thank you.
Ms. Koch, anything further today?
No, thank you, Your Honor.
Mr. Thompson, anything further on this case today?
Nothing further on this case today. Thank you, Your Honor.
All right, thank you. That's all for this hearing. All parties are free to disconnect. It also concludes the court's afternoon docket. The court will be in